Good afternoon, everyone, and welcome to our workshop, 2024 Legal Updates with Adam Dees. We are so happy that you've decided to join us today, and we are excited to provide you with some exclusive information and resources that will give you a deeper understanding of us and our services. My name is Emily, and I'm the Marketing Director for Clinkscale's Elder Law Practice, and we have our main office located here in Hayes, and then we also have our other office in Wichita, and we do serve clients and families throughout the entire state of Kansas. So today, I would like to invite you all to type any questions that you may have in the chat box that's located at the bottom of your screen. And then throughout the presentation, you can ask any questions you have. And then at the very end of the workshop, Adam will go ahead and address any of those questions or concerns that you do have, since this is going to be a lot of really good new information. So without any further ado, I would like to hand it over to our attorney and partner, Adam Dees, to get us started.
Well, thanks for joining us here this afternoon. I will tell you some years we do this seminar or this webinar and there's not a whole lot that has changed or is going on. 2023 and 2024 and 2025, which is what we're looking into the future, are not those years. There have actually been some changes. There are things that we can manage and that we can work through, but I think everybody just kind of needs to be aware of what those changes are. So I do want to make sure that everybody can hear me. So if you could just hear me, and if you could type in the chat box like a yes or a Y, just so that we know that everybody can hear and that we are good to go. Okay, I'm seeing yeses from a couple of people. Okay, good. Looks good. So I'm going to go ahead and share my screen very quickly. And again, we're going to go through, excuse me, quite a lot of information. I think it's really important information, excuse me, to as far as estate planning and long-term planning goes. But I do want to make sure that we try to get through everything. Okay, I do want to make sure I am sharing the right screen. There we go. Okay, so 2024 legal update. Maybe. There we go. So the first thing we're going to talk about this afternoon is some federal law updates, some retirement account changes. This has been from a couple of years ago, but it's still kind of relevant. It's not kind of relevant. It's still relevant and something that I do want to talk about and that everybody should be aware of. The new Corporate Transparency Act, which is a federal rule, how that kind of works, and the new requirements under it. 2004 Kansas probate trust tax law changes, and then again looking for new changes in 2025 as the Tax Cut and Job Act expires. Some of the provisions of that sunset here at the end of the year. So this is for you if you want the latest legal information, if you're wondering if you're prepared for the changing economics we're facing, the new legal structure, you want to preserve resources, don't want to pay too much in governmental taxes, and other transfer costs at the end of your life to your children. So if you could wave a magic wand, right? This is what we do. We try to wave magic wands, and you want to stay in control of your resources, not lose property because of the government, have peace of mind that everything is the way that it needs to be, and your plan is both strong and powerful to protect you, but also flexible enough to adjust as things change, then this is the webinar for you. So who are we? Most of you, seeing a lot of the names, you guys know who we are. We've worked with you over the years. What JC says about us is that Clinkscales made me feel like things were done right and on time, made me feel comfortable and at ease. But for those folks who don't know us, we're an elder law firm. We're focused on helping families preserve and protect their dignity, health, finances, their legacies. We've got practices again throughout Kansas, both in Wichita, Hayes. We began in 1983, so we just celebrated our 40th year. And then those are the partners in our law firm. We have hired a new associate attorney, Brandon Beaker. He's in our Wichita office. and we're working on getting a picture of him. So hopefully in the next couple of webinars, you'll see pictures of him. So who am I? Again, I'm an attorney with the law firm here, focused on preserving and promoting family harmony, passing on family legacies. And actually, I was talking to Emily. I am now in my 13th year. It's a little bit older slide. 13th year of being an attorney, and 8 years here at Clink Scales. So it's my family, my wife, my kids. Alyssa Kay is our oldest daughter with our dog Simon. He's a Cavalier King Charles Spaniel. And then our younger daughter, Rachel, hanging out there with Bridget, our plot hound mix that we adopted during the pandemic and keeps me on my toes. So why am I so passionate about this? Many of you probably heard this story, but I was a general practicing attorney for about 5 years. And then my grandmother called me and told me my grandfather had Parkinson's disease and asked me to help her figure out how to navigate that. And at that time, I really didn't have a great idea about how to work through someone with Parkinson's and that the progression of that disease. And so I changed my entire practice to focus on these types of issues and to keep people like you and like my grandmother informed and up to date with their estate planning documents to make sure that they can weather the storms that might come. So a couple of things my grandparents have taught me: family is first. Everybody grieves in their own way as they're going through these transitions, and that transparency, openness, and having a solid foundation and a plan works. So this is kind of what LD has told us about our firm. You did everything we asked for and more. My experience was wonderful. You gave me peace of mind, which helped the whole family through a difficult time. Thank you for all that you do. So what I want you to know is that knowing the changes in Kansas law will protect you and your wishes, provide for your family and your legacy. So what you're going to discover is that you don't have to go broke if you need long-term care. Careful planning avoids unnecessary taxes. Express your wishes. Again, some changes in the federal tax law, changes in this Kansas state tax law, as well as future law changes. And again, careful planning helps avoid these unnecessary legal hurdles and issues that can arise. So remember how I said we've got a lot of changes that are happening? These are all of the changes from the Secure Act 2.0, which actually started in 2023, but I just kind of want to recap some of these this year because they're still important. These are still the law, and then we're going to see as some things sunset here at the end of this year, how these might be impacted as those changes happen. So Secure Act 2.0 changed some required minimum distribution requirements. There's some charitable distributions from IRA changes. They added a savers credit, did some things with employer provided retirement plans and contributions, added a corporate alternative minimum tax rate, did some excess taxes on stock buybacks, which doesn't affect a lot of people here, increased the IRS funding. The idea was we had too many people sitting on hold with the IRS, and so we've increased funding to try and help that process, extended some subsidies under the Affordable Care Act, and then also tried to have some energy security and climate change investments. So we're going to talk about the federal law changes, then we're going to talk about some Kansas law changes, and then we're going to talk about the what we're looking for in the future on the horizon. So again, this is not new. This is from last year, but I do think it's important to kind of keep an eye on Secure Act 2.0 and how that law is now being implemented and how it works that now that we're in its second year. So in 2023, requirement and distributions moved up to 73. By 2033, those requirement and distributions aren't going to have to start until somebody changes, until somebody hits age 75. 2024, no required minimum distributions from Roth IRA accounts. The other piece of this is 2024 you can make some catch-up contributions. So you can start adding additional funds to IRAs, which Congress has allowed in order to help people getting closer to retirement, make sure that they can realize that dream. And so those are going to have to be treated as Roth contributions for people earning over $145,000 per year. So what that does is that just limits some of the tax deductions. Currently, there are catch-up contributions, which are about an additional $1,000 per year per person. They have indexed that to inflation, so you're going to see that $1,000 per year catch-up contribution just continue to go up as inflation goes up. And then in 2025, again, looking ahead to some changes, those turning age between 60 and 63 can contribute up to the greater of $10,000 per year, or 50% more than the regular catch-up contribution. So if your normal contribution is at $6,000, and then we've got an additional $1,000 contribution, you can actually, if you're between age 60 and 63, contribute up to $10,000 to that IRA, so that we can try to help boost those savings as we get closer to retirement. The other kind of cool thing with in 2024 is 529 to Roth IRA rollovers. This is a new thing, and I don't think it's going to be applicable to this group, but if you have kids or grandchildren that have IRAs, or excuse me, that have 529 plans, what they've said is that if those plans have been established for 15 years, which is a long time. So these are plans that are established when a child is very young. In those plans, you can move money from those plans over to a Roth IRA for that beneficiary. So, for example, my family, we set up 529 plans for our daughters back when they were young. And if they don't use those funds for college, which they're probably going to use them for college, right? But if they don't, we can move that over to a Roth IRA for them to go ahead and start their retirement savings at a young age. So, and then the other piece of that is that 529 plans have kind of a limited scope of use of just educational expenses. Roth IRAs have a much broader ability to use those funds, and they've decided that $35,000 is okay to move those over. So, all right. Additionally, let's see, talked about that. Talked about secure 529 plans. Charitable deductions. So it used to be that you could only make certain charitable deductions per year out of your IRAs, but now you can make a one-time $50,000 charitable contribution from your IRA. So go straight from your IRA to a charity. You can do that up to $50,000. They're going to start indexing that $50,000 until it gets to $100,000 qualified charitable deductions to that inflation. So again, there are just some more opportunities to make charitable contributions with your IRAs. Savers credit, the current limit was $4,000 a year. Married limit is up to $8,000 a year. Secure Act 2.0 removed those limits, or removed income limits for those contributions. So it used to be that those contributions could be limited by your income and how much money you made. You might not be eligible for those, but those were removed at this point. So, okay. 401k and 403b plan contributions. Again, we're going kind of really fast and through a bunch of this stuff. Part of it's because we went over some of this last year, and also because we've just got a lot of ground to cover. But there are some cool things they're doing with 401ks and 403b plans. So new employees have to be automatically enrolled in 401k and 403b plans. Then they can they can enroll at 3%. And then every year, those are automatically increased by 1% up to a 10% max. So you start out with your 3%. When you become eligible, that automatically ratchets up. Now, employees can opt out of this, but they have to opt out of it. Again, the idea is that we are trying to encourage people to save for retirement. The other cool thing that they did with the Secure 2.0 Act is if an employee makes payments on student loans, those payments can allow the employee to qualify for an employer match. So if you make, $6,000 in payments on your student loans, and that's 3% of your income, that it makes you eligible for that match. So again, your employer is contributing to your retirement even while your student loans are being paid down. So it's a pretty cool deal. The other thing that was new this year and is that they have started a database where people who might have lost retirement accounts, so they changed jobs, they moved, they don't, didn't keep track of it. There's now a database you can go look at, and don't pay for this. Okay, I did look at these databases, and there were some people that were charging in order to access this information. It should be free, but it's www.unclaimedretirementbenefits.com. Again, that allows you to find old 401ks or other retirement accounts. It's kind of like Kansas unclaimed property. So Kansas has an unclaimed property statute and database where it collects funds that were left at old bank accounts or retirement accounts or refunds or different things. This is the same type of thing. It's just done at the federal level, and it is only for like 401ks and retirement accounts. So it's not just normal bank account, normal investment account. It's specific to retirement accounts, and it's done at a federal level. So again, that should be a free service. So don't pay to try and find old retirement accounts. Okay, the big federal change this year, as it relates to most of the folks that we work with, is the Corporate Transparency Act's reporting requirements. So the Corporate Transparency Act is trying to determine if there are people that own LLCs, corporations, other businesses that may be shielding money, because unfortunately we have learned that the United States system can be used for fraudulent purposes, and they're trying to kind of tamp down on that. And that's what this is about. So what it does is it requires providing information about anybody that owns more than a 25% interest in an LLC, corporation, those types of things. It also requires senior officers. Basically, you need to input your name, your birth date, your address, and your identification number, which can be your social security number. You also have to provide a form of photo ID, which is your driver's license. You can be driver's license, passport, something like that. But the idea is that the federal government just kind of wants to track who actually owns these entities to reduce fraud. Existing entities have 1 year, so until January 1, 2025, to do their reporting requirements. And I'm anticipating most accountants are going to do these when they file tax returns, similar to most accountants filing the annual reports for a lot of businesses with Kansas Secretary of State's and other Secretary of State's offices when they do those returns, but I'm not sure. So you might want to just check on that if you do have a business or an LLC. If there's a new entity in 2024, you've got 90 days from the date of formation to get that done. If it's a new entity after 2024, then they shorten that down to 30 days. The nice thing about this is there are no annual filings as long as nothing with the organization changes. So as long as the owners stay the same, the officers stay the same, you don't have to go and do this every single year. You just have to do it once. But if there are changes, then you have to submit information about those changes. A couple of exceptions: if a corporation or an LLC has more than $5 million in revenue, they play by different rules. as far as reporting requirements. And so, we're not as excited about, looking at those if an organization employs more than 20 people full time. Okay, so that's full time employees. Um, or if it's located in the United States and they're located in the United States. So we have to meet all those three requirements: more than 5 million in revenue, more than 20 people fully employed, and located in the United States. Fortunately, it's an electronic um, filing that you have to go through, and so it's pretty slick. The biggest thing is getting that photo identification um, is requirement. So, all right, that's kind of the Fed side, and a lot of that stuff, was with Secure Act 2.0, happened in 2024. There, or excuse me, 2023. Still working on implementing. Still important, just to kind of refresh that information. Corporate Transparency Act for those people who have corporations, LLCs, partnerships, those types of entities. But Kansas has made some pretty substantial changes as well. Most of them are really in favor of families who want to pass on legacies, and it's going to make that easier, especially when we're dealing with smaller estates. So there's some probate code changes, there's some trust code changes, there's a little bit of changes in tax law, but again, those are all really beneficial for families. So most of the probate law changes are just increasing dollar amounts. So, for example, if we had a small estate that was under $45,000, I was just talking to a family about that this morning. There's an affidavit that somebody could fill out to have that passed on to the deceased person's beneficiaries. They have moved that $45,000 up to $75,000. Okay, that hasn't been changed in a long time. I wish they would adjust it for inflation. They haven't done that yet. Similarly, spousal allowance was set at $50,000. Homestead allowance was set at $50,000, and they have kicked those numbers up to $75,000 just to adjust for the time value of money. Similarly, creditor payments. It used to be if we had a creditor and that creditor was less than $5,000 in a probate, we could go ahead and pay that out without having any court order. Um, it just became that a lot of creditors are now in that $5,000 to $10,000 range, and so you would have to go to court to get to request payment of those. Now they've kicked it up to $10,000. Same about moving things from a magistrate judge to a district court judge. Got to get up to that $10,000 level in order to have that additional judge oversee those things. So just some changes in the dollar amounts for various things. Another big one, transfer on death deeds. So one of the main, I guess, I don't know if you call it an issue or one of the concerns about doing transfer on death deeds is that when you listed the beneficiaries, if something happened to those beneficiaries, then that could potentially start a probate for that beneficiary. Now, transfer on death deeds allow the listing of contingent beneficiaries. So if a transfer on death deed says, hey, I want to give this to my children, but if my children are deceased, I want it to go to my grandchildren. Or that, my grandchildren would step into the shoes of one of my children. Many of the families we work with have trusts or wills or other estate planning documents that don't, that avoid that issue intentionally. But it's nice to see that they have the Kansas has kind of cleaned that up and made it easier on families. The other interesting cleanup that the state did this last year was on the Slayer rule. Again, doesn't apply to a lot of people, but I kind of find it interesting. Basically, if someone kills somebody else, joint tenancy ownership was severed, inheriting from wills and trust was severed, but like payable on death beneficiaries for life insurance or IRAs or accounts or joint those payable on death weren't included in that severing under the Slayer rule. And so again, we just kind of cleaned that up. So you probably didn't think we were going to talk about things like murder and mayhem this afternoon, but hey, there we go. The other really cool thing that they did is if we do have minors who are set to receive resources from their parents, and something has happened to their parents, it used to be we had to do a guardianship and conservatorship, no matter the amount. Now, if the claims are less than $25,000, we don't have to jump through all of those hoops. And the reason is there are some really cool accounts like 529 accounts, ABLE accounts if someone is disabled, that allow us to handle those funds without getting court intervention and going to that expense. So again, some really positive things coming out from the state, making it easier on families going through those transitions after a loved one's die. So next fun one, the rule against perpetuities. I don't think when I was going to law school there was anything more misunderstood than the real rule against perpetuities. The point here is that you can elect out from the rule against perpetuities in trusts, which we do, which we have done for a long time, as long as there's an express statement, the rule it doesn't exist, and the trustee can sell, lease, or mortgage any property within a 21-year period. I can tell you all of our trusts have already been doing this. It's just kind of nice to see that Kansas has adopted statutes that specifically provide for that. Okay, the other big change in Kansas law is decanting of trusts. And for all my wine aficionados out there, or for those who are not wine aficionados, decanting is the process where we take wine, put it in a container, wait some time to allow it to do its thing, and then we decant or pour it into something else that then changes the taste and the chemical properties. Okay. Kansas has said you can do the same thing for trusts. What does that mean? That means that if we have some old trusts out there that may not be completely up to date with the laws or the changes, we can take that trust and just say, hey, we're going to pour over, we're going to decant, we're going to move these assets into a new trust that embodies the new laws, those types of things, and make it easier and bring it up to date without a whole lot of issues. There are a couple of caveats to that. It cannot increase or decrease a beneficiary right to distribution. So I'm kind of curious to see how they do this with supplemental needs people and trusts that may not have some supplemental needs language in it. But then we have a supplemental needs person that we need to, include that language. And the other big one is it can't increase trustee compensation, because the idea is that this is the trustee taking the resources in one trust and moving it to another trust. So we can't have them, benefit from that transaction. So I'm not sure exactly how much we're going to see this use, just because the majority of trusts are changed or modified through amendments, restatements, redoing things in that way while the grantors are still alive. But it's going to be something that we'll see in trusts in the future as an opportunity to, again, update trusts for changes to the law as time goes on. And I think what the trust and estate planning community is learning is that some of these trusts go on for a really long time and the situations change and tax laws change and benefits laws change. And so we just need to have these tools to still provide the protections that the people that you are putting in place, while also having the ability to make changes for that. Okay. State tax law changes. I was going to look this up because I know there are several bills in front of the Kansas legislature. I was going to look it up today, but I didn't before we got on here. So this is kind of how things are progressing at this point. January 1st, 2023, there's a preferential sales tax rate for groceries. In 2023, it was 4%. Now we're in 2024, it's 2%. 2025, we will not have sales tax applied to groceries. There is still a tax on food, or counties and cities can still tax food and food ingredients. And the other piece of this is doesn't apply to alcohol and tobacco. So there will still be a sales tax on alcohol and tobacco. So if you're looking, you may have already seen a couple of different tax statements show up on your, um, or excuse me, when you buy your groceries, there may be 2 or 3 different taxes imposed, which is because they're pulling out that state sales tax for part of it and not for other part of it. I know there was a lot of confusion surrounding that. The other nice thing is that 529 plan contribution limits have increased again, 17,000 per year per beneficiary. That matches the gift amount. And then you can do a total of $450,000 per beneficiary. Again, that's just inflation at its work. So some potential changes in state law, or some potential changes coming up. Long-term care insurance tax, we'll talk about that and what some other states are doing. Medicaid expansion, which we're still waiting on, crossing our fingers on. And then, of course, the sunsetting of the Tax Cuts and Job Act provisions, which are going to happen here at the end of 2025. And there's some substantial things to look for with those sunsets, assuming that Congress does not act. And I think we can all see the ability of Congress to act. So long-term care insurance, we talked about this last year, but I do want to talk about it again. Washington State says that if someone does not have a qualified long-term care insurance policy, then that person is going to pay a surtax of 58 cents per every $100 of income. Um, Basically, the idea is that that's going to go into the Medicaid pool to help pay for long-term care costs. And so basically, instead of purchasing your own personal long-term care insurance policy, you're doing it through the state through this tax. Okay. The Kansas has not considered this, to my knowledge. However, and kind of what I pointed out last year when we looked at this, Missouri is considering it, Colorado is considering it, and those are Illinois are considering it. Those are what I would consider pretty conservative states. And they also border us. Colorado maybe not so conservative, but certainly Missouri, Illinois. And so if they're looking at it, it's probably something that we're going to be seeing here in the future at some point, at least considering. So if you have long-term care insurance, this is just another reason to keep that long-term care insurance. If you're thinking about whether or not that's something that's right for you and your family, if this comes into play, that'll obviously have an impact on that decision. So the next one, Medicaid expansion. This has been attempted multiple times over the last years, especially while Governor Kelly has been the governor. We found that 7 in 10 Kansans support Medicaid expansion. Right now, 150,000 Kansans are left without health care because we don't have Medicaid expansion. Only 11 states have not expanded Medicaid. And what it is basically we would say, hey, we want to expand Medicaid. We want to offer it to some additional people. 90% of that's getting paid for the federal government. We have to kick in 10% for the state. And passing that would save Kansans about $70 million. The other piece of that is that most of those funds would end up going to rural hospitals or local hospitals where those folks that don't have Medicaid at this point, but don't have employer provided health insurance where they live. And so those funds would flow into those communities. And that's probably why it's so popular at this point, but for whatever reason, we can't seem to get it passed. So, okay. That's a lot of information. We talked about kind of the old stuff, the Secure Act 2.0, what we covered last year, some of the changes that it's still important to be mindful of, what's happened in Kansas here in the last year with some increasing in the limits as far as assets that you can transfer without a probate, ways you can do that, some things that we're looking at on a state level as far as long-term care insurance expansion, Medicaid expansion, those types of things. And now and now on top of all of that, right, if that's not enough, we've got the Tax Cut and Job Act sunsets. So right now, The income rates, when they're applied to single people, would be over $11,600. So that's the personal exemption. Applies to married people filing jointly with income over $23,200. And then you kind of get a standard deduction on that of $14,600 currently for married people filing jointly, about $29,200. What happens with the sunset is we go back to pre-tax cut and job acts. And so it's going to cut those numbers down in half. Okay. What that means is that prior to the tax cut and job TCJA, you had a lot more people itemizing their deductions, because itemizing their deductions was a better tax outcome than just going with the personal exemptions and the standard deduction. Because that goes away, we are going to see more people itemizing their deductions. And one ways that they're going to do that, the TCGA had capped at $10,000 how much you could deduct for state and local tax deduction. So like real property taxes, state taxes, you could deduct those from your federal income tax, but that was capped at $10,000 with the TCGA. Now that goes away. And the personal exemption return, so each taxpayer and qualified dependent receives about $4,050. So when you're looking at a married couple, that would be $8,100, right? Well, if your itemized deductions get above that, then it's more advantage. It's a better tax outcome for you to itemize. So that's what we're going to see. We're going to see people going back to itemizing their deductions, assuming that Congress doesn't act. The child tax credit. It was up to $2,000 for children up to age 17 and $500 for children age 17 and age 18. Now it's going to revert back to $1,000 per child up to age 18. And we're going to start phasing that out again at $75,000 for individuals, $110,000 for married people filing jointly. Okay. Again, the mortgage and home equity interest deduction limits return, which again, that's one of those itemized deductions. Miscellaneous itemized deductions when it exceed that 2% of AGI and exceeds that personal exemption, which is much less lower. And then we're going to also have more people in needing to file alternative minimum tax, which is basically a tax code within the tax code. What you need to know is right now that applies to people making $85,700 as an individual, or people making $133,300 as a married people filing jointly. Again, those numbers are going to go down, and so more people be effective.
I cannot hear with your noise.
Let's see. The other piece of that is there are some major changes to the gift and estate tax code. Now, having said this, I got to preference this. In no time has the federal gift and estate tax exemption decreased, because Congress has continued to usually renew it at its current level. They may even do it retroactively. But again, we're kind of wait and see what happens. So right now, the individual exemption, so one person can transfer during their lifetimes and at their death, $13.61 million. And that's adjusted for inflation. And a married couple can transfer that much without paying taxes on that transfer, $27.22 million. At the end of this year, those exemptions go down to about 7 million. Again, that per person. Again, that depends on inflation. And the married couple exemption about 14 million. Again, that depends on inflation. So what that means is that people, and I'm going to say people even down to 4 and 6 million, that have between the two of them about $8 million, $8 or $9 million, are going to probably want to think about making sure that their estate plan is set up so that it plays by the lower numbers rather than the higher numbers. The idea is that if Congress doesn't do anything, that the families will be safe and protected. And I know, kind of looking with the families that we've been working with, if people are approaching that $7 million at total resources, we're really taking a look at, okay, what are some tax planning strategies we can use in order to adjust their taxable estates to take advantage of the full $14 million between the two. Because the idea is that resources or assets are going to continue increasing in value even while those exemptions go down. So we want to, we want to avoid hitting those breaking points with some bad timing. So how do we respond? What do we need to do to take all of these in effect? Again, there are fundamental documents needed to protect you and your family. I don't know if you guys have heard us tell the story about James Dean. He died September 30th, 1955. He didn't have a will. He didn't have a trust. Everything in his estate went to his father, to whom he was estranged. So the kind of the one person that he didn't want to have those resources ended up with those resources. Now his estate, right, earns about $5 million a year, and that all goes to his dad, and there's a foundation set up and different things. But it probably wasn't what he wanted. And so that's where having those fundamental documents in place went well. I'm going to jump through some of these other things because just kind of time constraints. So if you have those documents, great. If you're wondering how these changes affect your specific situation, schedule a strategy session with our office, okay? On top of making sure that your planning can adjust to these types of changes as time goes forward, because although I don't think there are going to be a lot of changes in the near future, I probably would have I'm sure I said the same thing last year with some of these things on the horizon, and there have been some pretty big modifications. Additionally, at that strategy session, we can talk about ways to preserve, protect your assets from cost association with aging, from home care to nursing home. And you can make the decision on how to pay for care, how to make sure that you don't go broke if you need nursing home. Again, if people want to protect each other. So let me just kind of go through a bunch of these things. So far, we've talked about how to plan for the Tax Cuts and Job Act sunsets. There are important considerations, components like powers of attorneys, wills, trusts, transfer on death deeds, transfer on death designations on different accounts. And we need to make sure that all of those pieces fit with your plan so that we can preserve and protect your resources, both from these types of changes, from long-term care, so you don't have to go broke, and you can avoid paying unnecessary taxes to the government. So again, with proper planning, checking in on those plans, you can delay or avoid nursing home, allow you to stay home longer, and also adjust for these. So again, I know we've gone through a lot of information in a really short period of time, but I hope you get this one thing, and that's proper planning, which a lot of you guys have done and worked with our office, allows you to achieve long-range goals, protect your wishes, your family, your property, and manage these types of changes, which are all completely manageable by being proactive and ahead of the game. So again, if you haven't talked to our office and you want to make that happen, you can set up a strategy session with us. We'll talk about important components for your long-term plan, again, way to preserve and protect assets, and then ultimately the way to stay at home or to allow those resources to benefit you and your family and not go to individuals whom you don't want to. So for those of you who don't know how this works, we do have a short phone call with our office to make sure that we can help you before talking with an attorney. We have a 60 to 90-minute strategy session, either in person, by Zoom, sometimes by telephone. Be with me or one of the other attorneys. During that time, we discuss legal, financial needs, review your current estate plan, concerns about preserving, protecting assets, your wishes, talk about your long-term goals. Maybe those goals have changed since the last time we talked. Discuss tax consequences, explore ways for you to stay at home, for your resources to work for you because you've worked really hard for those resources, and then answer questions about your unique situation. At the end of that time, you're going to have a better understanding the issues, the goals, your situation. We'll have a plan, again, that can be flexible enough to move with you as you move on your journey, and you'll know what documents and other tools you need. So here is the phone number you can call to see if you qualify for a strategy session. Emily, I know, is going to send out a survey monkey asking you about how this presentation did. And if you click on that, you'll be able to get that information. We've also, and I know a lot of you guys have read this book, but if you haven't, what you really need to know for the second half of life. And after meeting with us, we'll give you a summary of our recommendations and kind of what you can look forward. So remember, give us a call, click the survey link, and we'll look forward to talking with you. Oh. So, hey, Emily, I have not been watching the chat, but are there any questions or any concerns that people have brought today?
There are a few questions. This is a good question here. On 529 to Roth IRA conversion, is
Yep.
the 15-year requirement from plan date of inception or last contribution date?
Great question. So the statute says it's 15 years from when the plan began. So the plan has to have been in existence for 15 years. It's a long time to have those plans in existence. Again, I think this is honed at families who have set those up when their children are young. And then they've discovered that, there may be several $1,000s that were not used for a child's education. And so rather than just kind of have those sit there not doing anything, we're like, okay, let's see if we can give people a boost into retirement by allowing those conversions to happen. Great question.
There also is another question. I'm not sure if you can cover it. It was about midway through the presentation. The question was, in Washington, if someone has long-term care, do they need to pay the tax?
I am not a Washington attorney, and I know that there are some long-term care insurance plans that provide for that meet the requirements of the statute. I'm not sure what those requirements are. And so you could talk to somebody, an elder law attorney in Washington, that would have a better idea of what those requirements are. I just know that if Washington has done this and Missouri and Illinois are considering it, it's something that we kind of just need to keep watching. And we are going to keep watching it for you guys.
Perfect. Thank you for providing those answers for those questions. If you do have any more questions at this point, go ahead and put them in the chat as we kind of wrap up for this afternoon, so that way we can still cover them while we're here live with you. But like Adam mentioned, you are going to get that follow-up email from me that will contain the SurveyMonkey link. And on that link, you can fill out if you want that book, or if you want to see if you qualify for that free consultation, you can do that on that link. The other thing the email contains is a recorded session of today's webinar. So it will be a YouTube link, so you can share it with your friends, family, coworkers, anyone that wasn't able to join us today, or so that way you can go through and take more detailed notes on all of the very specific information that Adam gave you today. It also has our phone number and our email in it. That way you can ask us if you have any questions that come to you after today. Thank you very much, Jerry, for that really nice shout out she put on there. I'll go ahead and read it really quick. She said, my husband and I have worked with Clink Scales recently, specifically Adam and Thea. They were so helpful and patient with all of our questions. I would highly recommend them. So thank you so much for putting that out there. That's great. But like I mentioned, if you have any questions, please go ahead and contact us for the free book, see if you're qualified for the free consultations. And thank you so much for joining us today. Thank you, Adam, for all that great information. Have a great day, everybody.